Intellectual property and confidential information. You need to know about intellectual property. If a contract is for the sale of goods, there is often no need to be concerned with the seller's intellectual property rights, IP rights. However, in a contract where one party is providing a service to the other, then protection of IP rights can be very important. Let's say that a designer is commissioned by a record company to design a cover for new music CD. The CD sells millions of copies and the record company then wants to use the cover design to merchandise such as t-shirts. Who owns the design? Is the designer or is the record company? It is important that the contract between the two parties makes this clear. Confidential information. Confidentiality protects information not capable of IP protection. This includes commercial information, trade secrets, and processes used by businesses in its everyday operations. This type of information is sometimes referred to as know-how. This information can be very valuable indeed in the hands of rival organizations. The business needs to include a confidentiality clause, sometimes called a non-disclosure clause, in all of these employees' contracts. This will prevent any employer from, for example, giving information from the database of clients to any third party. Sometimes it's not always obvious to business how valuable its intellectual property or confidential information might be. Many law firms now offer the services of carrying out what is called an IP audit for companies. The law firm will identify what intellectual property and confidential information a business has and give advice on how to protect it. I hope you enjoyed this video. I put a lot of legal information in it that you need to expand your legal knowledge. Please subscribe to channel and turn on notifications to listen my next podcast first. Thank you for listening Maral Advocate YouTube channel.